the appeal of Ian Green against Public Service Commission.
Mr. Dass, Mr. Thompson, Mr. Knox, it's a great pleasure on this occasion to welcome Sir Anthony Smellie, former Chief Justice of the Cayman Islands, who is today sitting for the first time as a member of the Judicial Committee of the Privy Council. We congratulate him on his appointment, and we greatly look forward to working with him.
Thank you. My Lords, Mr. Dass and I discussed this over the weekend, and we would like to echo, if we may, those compliments and sentiments.
Thank you, Mr. Knox. Mr. Dass.
My Lord, thank you. In this matter, I appear together with Ms. Tamara Tulsi for the Appellant, the Public Service Commission. My learned friend, Mr. Kenneth Thompson, is appearing virtually for the Respondent, Mr. Green, and my learned friends, Mr. Peter Knox and Mr. Strang, appear for the interested party, the Chief Personnel Officer. My Lords, there have been a couple of supplemental bundles that have come in. I trust that the board has had sight of them.
Yes, I think they've reached us, and we have them in electronic form.
Yes.
We'll be working off the electronic bundles.
Right. The appeal. These are two appeals in this case. The first part of the appeal is on the merits of the case, which is really arising from a judicial review of a decision to promote certain officers within the civil service, namely the fire service, which is established by statute. And the regulations in question was that the candidates had to have certain prescribed qualifications. Am I not loud enough? I'm sorry. Yes. Now, the case that was advanced was very simple, which was that Mr. Green advanced a case that he had equivalent qualifications and should be considered as the other persons, and he was wrongfully excluded. The case was decided on a relatively simple but entirely correct basis by the first instance judge, which was that Mr. Green did not have the qualifications which were prescribed. In particular, he did not have a determination of equivalence by the CFO. Now that is a very important point in the case, in that it's not that he has to have a qualification, that it is for the Service Commission to determine his equivalent, or for this court to determine his equivalent. It is that he had to have a determination of equivalency by the Chief Fire Officer after following a prescribed modality of consultation. Now, I make that point at the outset because besides all the paper that has been filed and all the stages of the case, it is still very clear that there is no determination by the Chief Fire Officer that he has an equivalent qualification. And I'll take you to the facts in a little bit, but I make that point at the outset because it means that he could not possibly be found to have qualified, and the decision on eligibility, which is a determination for the Service Commission alone to make, is obviously correct. And even now, that stands as a matter of fact. Now, it's a matter of fact also that he is the only candidate who does not have the relevant prescribed qualifications. Everybody else on the list has it. What he was in fact trying to do was to use his various management qualifications as a platform to exempt him from having a technical firefighting qualification. That also is undisputed in evidence. The prescribed qualification, and I'll take the board to the relevant regulation, which is Regulation 8, is the Graduate Diploma of the Institution of Fire Engineers. He doesn't have it, and he doesn't have anything that is equivalent to that. But more than this, not only did he not produce a determination of equivalency, he effectively concealed a determination that it was not equivalent. He had applied, and he had been rejected. The Chief Fire Officer made a determination that the particular qualification, the management diploma, was not equivalent, and he did so echoing the reasons after the consultation that, unsurprisingly, a management qualification didn't seem to in any way equate to a graduate diploma of the Institution of Fire Engineers. Now, Mr. Green does not dispute that he was told of that in 2006, 11 years before. He doesn't dispute that he never challenged it. He doesn't dispute that he didn't disclose it to the court. What he then does is he segues into various things suggesting that maybe that determination could have been incorrect.
Was it 2006?
2007.
Yeah.
Yes.
That's the memorandum of the 11th of May 2007?
Yes, that's correct, my lord. And more than that is that he also gives no explanation for why in the many years that passed before the decision in question, why he made no effort to get the requisite degree, apart from the fact that he never challenged it. Simply unexplained on the evidence. So that is the factual outline of the case, and none of those facts are in dispute. Now,
It's presumably in dispute that he concealed that refusal.
Well, he accepts that he accepts that he was told, so he doesn't deny that he concealed it.
No, he was told.
Yes. So what I mean is that even the act of non-disclosure is not in dispute.
He might have thought it would have been on his file.
Well, when I say not disclose, I mean he didn't disclose it to the Judicial Review Court.
Oh, I'm so sorry.
When he came to
you
court,
meant to the...
what he did is, and I'll take you to it in a moment, is he produces the first provisional view of the Chief Fire Officer that suggests that he had an equivalency. And then by omitting the actual determination, he gave the impression that he had a determination of equivalency. So that it was an act of positive misleading in his case. And there's no dispute about that. It's admitted even in the
You say the actual determination.
Yes, ma'am.
But that memorandum of the 11th of May 2007 was disavowed by Mr. Skeet
Yes, ma'am.
in his evidence.
Yes, my lord.
And I seem to recall the Court of Appeal commenting that his disavowal was not challenged.
Yes, well, my lord, I will take you to what that disavowal means. But there's a difference between, and this is an important point, there's a difference between a decision that is made and unchallenged and never revisited, and in which a witness comes 10 years later and says, oh, that's not what I meant, or I didn't authorize it.
Or it wasn't my decision.
Or it wasn't my decision, yes. And a decision that is challenged on that basis. It's never challenged. Even when that happened, Mr. Green never amends his case and says, that decision was wrong. He never challenged it. And I'll take you to what Mr. Skeet says, which is itself ambiguous. And Mr. Skeet's evidence, and I'll say this at the outset, has to be viewed with considerable circumspection, because it is very clear in Mr. Skeet's own affidavit that he was aware of that determination, because he refers to it in a contemporaneous document, and I'll take my lord to that, and I'm grateful for it being flagged. So that is the outline of the case, and what we say is that much of the error of the Court of Appeal in overturning the decision of the first instance judge arose from their allowing various departures from what the case was about. Secondly, from their misunderstanding as to what the proper constitutional relationship is between the Service Commission and the executive under the Constitution. And thirdly, in not appreciating the proper factual matrix that actually existed and which was unchallenged before them. Now, I note as well that...
Sorry, is that third point distinct from the first point?
The third point being the factual matrix.
I thought you'd already given us the outline of the factual matrix as you thought it.
Well, I've touched on it. Yeah, I mean,
okay.
Forgive me.
Yeah.
Now, just as a matter of completeness, I note that there is no challenge to the delegated legislation made under the Fire Service Act, which is delegated legislation made by the Cabinet, who's not a defendant to this case. So the points that I intend to sort of outline is that first to say that the Court of Appeal was wrong to read down any aspect of the legislative regime based upon its misunderstanding of the constitutional divide and the role of the Service Commission. They misconstrued Regulation 8 and the role of the Commission under the Service Commission regulations, Regulation 160. and they did not properly appreciate the facts of how the decisions were taken. Now, on the first point of the constitutional divide, it is now well settled that it's not for the court to improve the constitutional protections under the Constitution. It's merely for the court to give fidelity to it. And that's been upheld more recently in Doré. That was also the point that was in Mirage number 2, which is the appointment of the Commissioner of Police case, which I will take my Lords to it. And that's also the effect, properly understood, of the whole Endell Thomas line of cases, which always said that there's nothing exceptional in the employer determining what the requirements of any employee should be. And of course, that makes perfect sense because it is for them to determine who they are employing and what the qualifications for that office should be. The only interposition under the Constitution into the ordinary employer-employee relationship is the fact of the Service Commission. And the Service Commission, which I represent, the Public Service Commission, is established under the Constitution. And in section 121, which is at electronic bundle 898, if you want the reference, 1211 says that subject to the provisions of the Constitution, power to appoint persons to hold or act in offices to which this section applies, including power to make appointments on promotion and transfer, and to confirm appointments and to remove and exercise disciplinary control, shall vest in the Public Service Commission. And then under 129, it's given power to make rules and regulations for the exercise of those powers. Now, that is sometimes very neatly described as the appointing power, the promotion power, and the disciplining power. And it's once everything else relating to public employment is simply for the executive to do, or it is for, if the legislature regulates it, it's for the legislature to regulate. Now,
Sorry, what were the three? There was the appointing power, the promotion.
Yes, promotion and transfer, and exercising of disciplinary control. So appointing, promotion, and disciplining is usually how it's sort of shorthandedly described.
Yes, thank you.
Now, what the cases say is that everything outside of that is for the employer to do, and that's unsurprising. So that what we say, and this is the point that was specifically argued in Mirage number 2, which was a case involving the terms and conditions of the Commission of Police, and that case is at 1736 in the bundle. And what happened in that case is that the legislature said that when the term of office of the Commission of Police came to an end, the executive, the cabinet, could, if it wished, extend it for a year or 2 years, if it wished. And a judicial review challenge a constitutional challenge was brought on the basis that to give the executive the power to extend the tenure of the Commissioner of Police was inconsistent with the constitutional separation of powers. And what the board said, echoing the learning from Endell Thomas down, was that is a term and condition. Tenure is a term and condition of employment. It had nothing to do with appointment because the person who was the incumbent had already been appointed by the Service Commission. They were not promoting him because the commissioner was already in the most senior office, and they were not disciplining him, quite obviously. So the simple point was that there was no basis or no metric against which to say that anything was unlawful about the legislation that gave this power to the cabinet. Because the simple question that had to be determined was, are you encroaching upon the power of the Service Commission or not? And that's all you had to do. And similarly, in this case, there is no question that the legislation in question or the regulations that are made under Regulation 8 have anything to do with interfering with appointment or promotion. It's all still being done by the Service Commission. The question is whether the particular qualifications can be set. And as my learned friend Mr. Knox has pointed out in his submission, across the whole civil service, terms and conditions of employment and qualifications are prescribed routinely, as one would expect. So that we say that it's clear from Mirage number 2, which is at 1736 that I just referred to, it's clear from the decision in Ramsahai, which is at electronic bundle 2112, it's tab 40. In that case, what happened was the minister had the power by regulation to impose a minimum qualification for office. And it was found unexceptional by this board. And in Finbar Boland, again, it was found there was nothing controversial, is the language that the board used, about the Court of Appeal's acceptance of the principle that the Commission had no power to lay down terms and conditions, and in that case, the particular specification was a time limit of, was it a time limit? Or an accounting qualification in Finbar Boland.
And the reference to that?
Finbar Boland is 2226, and the paragraph that I referred to is paragraph 28 to 29, where they said there's nothing controversial about that. So that's, so the simple point is that there's a long and quite distinguished body of law dealing with this, that the Court of Appeal has acted inconsistently with. And there is certainly nothing in the Constitution that suggests that Regulation 8 is in any way encroaching upon the power of the Service Commission.
Is it the case that the argument made by the Court of Appeal has not been explicitly addressed in previous case law? That is, that the question of eligibility, according to the Court of Appeal, is a matter for the Public Service Commission. Has that point been explicitly argued and addressed?
It has, my lord. And then, and just to make the point that I'm not dealing with the eligibility point, I'm dealing with the, well, but there's 2 points, and I'll take my lord to it. The first point is that there's a specific decision on equivalency which must be determined to see whether somebody has a qualification. Then then there is a decision of the Public Service Commission on eligibility that they must take into account, looking at all the qualifications, and they must decide whether that meets the standard. So there's a decision as to whether a particular qualification is equivalent for the purpose of qualifying, but there's a broad decision of eligibility. Now, the most recent case on this, which is on point, is the case of Ramsaran. I think, my Lord Burrows, you sat in that case.
Yeah.
No doubt why you're prodding me to it. And that case makes clear that the decision on eligibility is entirely for the Service Commission. The Chief Fire Officer can make what recommendations he wishes. That cannot bind the Service Commission, either by including somebody who is wrong or by excluding somebody who is ineligible.
And the authority is Ramsaran.
Ramsaran, and that is, give me one moment and I will tell you the page number.
The question is whether of the eligibility of a given individual.
1505, yes.
So
whether
you're applying it to the facts of the particular case, whether a person is eligible, and that's a matter for the PSC.
That's a matter for the Commission.
If you take a step back from this and look at the question of qualifications.
So the first question is, yes.
Then that's rather different, isn't it? That's a matter for the executive.
That is a matter for the Chief Fire Officer under Regulation 8. And I will, let me, this might be a helpful point just to get to that regulation now, so we can see how it actually works. Now,
that's a question of equivalency.
yes,
Yeah.
whether you have the prescribed qualification or not.
But I think the Court of Appeal was here concerned about the appropriateness of the President being required to promulgate regulations
Yes.
or qualifications, and whether that was an infringement of the Commission's responsibilities,
Yes.
which included the appointment and promotion.
Yes, absolutely.
I think the Court of Appeal expressed itself in terms that it was illogical that that power should reside anywhere other than with the Commission.
Yes, my lord, and that is the point of the past authorities, is that all of them speak with one voice, that actually it has always been the case that the promulgation of qualifications was a matter for the employer, whether regulated by legislation and given to it, but it has never been part of the role of the Public Service Commission. And the fallacy of the Court of Appeal's approach is based very simply in looking at, and this is what was argued in Mirage number 2. This is the very point that was argued. The fallacy is unless you can look into Section 121 and say in that section, or some other section of the Constitution, it is part of the role of the Service Commission to prescribe qualifications for particular officers, then there is no encroachment. And that body of law follows from Endell Thomas to Cooper and Barbosa to Ramsar High to Mirage number 2. All of them speak with one voice on this issue.
Of those cases, Ramsar High seems to have been the one considered by the Court of Appeal.
They did, yes.
Its own decision, which went before the board,
Yes.
and was upheld in that respect, but the Court of Appeal departed from its own decision.
In Mirage number 2, my lord, which I was involved in, we won in the Court of Appeal on this very point. It was the same point that was argued, and we won. And it went up to the Privy Council, and the Court of Appeal's judgment was upheld. So I'm saying it is surprising that the Court of Appeal took the position it took in the face of the considerable body of law on this issue. And we say, with great respect to the Court of Appeal, we say they were simply wrong to construe it in the way that they did, as though it had to be read down. There's no basis for it, either as a matter of principle or as a matter of authority.
So you say the crucial case, although earlier cases may be consistent with it, but you say the Ramsar case is the clearest authority on this point.
Well, I would say, Mirage number 2 is very good, because in that case there was legislation that gave the power to the cabinet, and it was argued in a lot of detail. And in that case, the board made the point that it's not for the board to improve the protections that are created in the Constitution. It's simply to uphold them. And this is set out in our written case, my lord, at paragraphs. I think from about paragraph 84 onward, you will see that 74 to 84, where we go through the body of law, starting with Endell Thomas, which is the first case that sort of decides this, and coming down to Mirage number 2. But like I said, so I don't intend, unless the board wishes me to go through those cases in any more detail. I think they are quite settled. Instead, what I will do is to go to the regulation itself to see what in fact happened in the case and what the regulation required. Now, the regulations are...
Before we move on, just to be
Yes, my lord.
sure we understand, you say it's quite settled, but as I understand your argument, it is that while the point was not directly decided in any of those cases, implicitly, in those cases, and they all ended up before the board, by accepting that the regulations were lawful, the board implicitly accepted that the executive could make regulations prescribing qualification criteria.
I mean, in some of the cases it's implicit, but in some of them it's more explicit. And that was the very point that was argued in Mirage number 2.
I see.
They said that the statute, in that case not delegated legislation, they said the statute was unconstitutional because you could not give this power to anybody but outside the Service Commission. So that was the point that was argued in Mirage.
I see.
I think it may have been the point argued in Barbosa. Yes. So it's not. It is implicit in some of them, like in Ramsar High. But in Ramsar High they accepted as well that it's lawful. It's lawful for the minister to prescribe the qualification. They had no problem with it. So it is more than merely implicit. I think that it is clear. That's from some of the earlier authorities.
I see.
Now, my lord, there are two sets of regulations that are relevant. The first is the Fire Service regulation that are made under Section 34 of the Fire Service Act. The regulations they start at 1187 of the bundle. They are promulgated by the cabinet. They say by the president, and that means the cabinet, who is not a defendant to the case. And what Regulation 8 says is that, and this is the key regulation that is in question. That's page 1192 of the record, the electronic bundle. the regulation says that on satisfying the requirements of regulation 2 or 3, a candidate for appointment to the office of fire station officer, which is the office that we are concerned with in this case, shall be a person holding the office of fire substation officer, which is what Mr. Green was at the relevant time, and who A, has either passed a job-related written examination, or B, is the holder of the graduate diploma of the Institution of Fire Engineers or equivalent related qualification as determined by the Chief Fire Officer after consultation with the Permanent Secretary and the Chief Personnel Officer. Then of relevance also is on the next page is 3, is where a candidate for appointment to the office of Fire Substation Officer has served for at least 5 years, he shall be required to pass examinations in management studies conducted by the examination board. So that there are 2 purposes that are served by the rule, the regulation. One is that you have to have a management qualification. And 2, you have to either pass the job-related written examination conducted by the board, or you have the holder of graduate diploma of the Institution of Fire Engineers or equivalent determination. Now, in this case, Mr. Green did not have A. He did not have the job-related written examination. Many of the other candidates did, and when I take you to the list, you'll see that. And neither was he the holder of the graduate diploma of the Institution of Fire Engineers. So the question that arose was whether he had an equivalent related qualification as determined by the chief. Now, there are, to harken back to the question that my Lord Burrows had pointed out to me. So there is a decision to be made on whether someone is eligible, and that means that the Service Commission has to look at the candidate and make sure that they have all of these things. They have management, they have either A or B, etc. And it is clear that that determination is theirs. But there is a specific earlier determination that can be made, which is the determination on equivalency. It means that a candidate could say, well, I am the holder of I am a fire substation officer, so I've ticked box 1. And 2, here is my determination from the Chief Fire Officer saying that this other qualification that I hold, is equivalent to the graduate diploma of the Institution of Fire Engineers. And again, that is ultimately, it's a question of fact. You either have it or you do not. Has the Chief Fire Officer made a determination or has he not? Now, so the first decision on equivalency is of some importance because it is the laying down by delegated legislation of the requirement to hold office. And it is a matter of some importance that one would expect for a fire substation officer to have some sort of technical qualification in fire services and not just a mere management degree. One would expect that they would have, he's not being hired to manage people only, he's being hired in the fire service. Now,
so 8.1 relates to technical firefighting matters?
Yes.
8.2 and 8.3 deal with management
That's right.
matters. Nothing may turn on this, but can you help me as to the difference between 8.2 and 8.3?
It is, I'm not entirely certain.
Well, we won't take up time
Yes.
if nothing turns on it.
Yes, I can.
I was mystified.
I'll flag it and try to come back at it, because I have it highlighted here as well, but I had the 2 of them, even though I think nothing turns on it.
It seems to be pointing at 2 different examinations. One is English and management studies, and the other is just management studies.
Yes. So there
But
could be overlap.
Who has to sit them?
Yes.
Doesn't seem to differ between 2.
No.
Yes. Now, on the facts, what happens is that an application is made for equivalency. An application is made for equivalency by Mr. Green. That is at EB 359. You will see that this is a memo from the Chief Fire Officer. And he says that he's in receipt of an application from Mr. Green, from Fire Substation Officer Green, who is seeking to have his postgraduate diploma accepted as an equivalent related qualification as set out in Regulation 8.1b. So
Was this 993? Did you say?
This is 359.
Oh,
Sorry.
completely wrong.
It should be a memorandum dated the 15th of July, 2006.
Yeah.
Sorry, 12th July, I'm told. So this is the operationalizing of Regulation 8. He's invoking the process for getting a determination of equivalency. And what that determination is, the process that is prescribed is the chief fire officer must consult with two other persons to make a determination. Now, this is what Mr. Green puts before the court in his application for judicial review. He says, look at this letter from the chief fire officer. Now, if you look at the letter, you will see at the bottom of the memorandum, if you look at the bottom of the page, you will see that that the position of the CFO is set out. What he says is, particular attention was paid to the letter from the School of Business. These are all attachments to the letter. The various qualifications are attached to this memo. Particular attention was paid to the letter from the School of Business, which concluded that the syllabus covers a wide area of management, which is even higher than that obtained on the syllabus for promotion within the fire service. And then he says, and this is the part that Mr. Green relies on very heavily in his case, he says, subject to the concurrence of the PS, the Ministry of National Security, and the Chief Personnel Officer, the Chief Fire Officer has no objection in accepting the postgraduate diploma in human resource management as equivalent. So just a couple of points just to observe. The first thing is that the Chief Fire Officer has not made a final determination yet, because he still has to consult, which is the prescribed process. The second point is that he's obviously asked himself the wrong question, because what he says in the bottom of the page is he says, particular attention was paid to the letter from the School of Business, which concluded that the syllabus covers a wide area of management, which is even higher than that obtained on the syllabus for promotion within the private. That's not what he's being asked to determine at all. The regulation says he must determine whether it is equivalent to a graduate diploma of the Institution of Fire Engineers. So the Chief Fire Officer, to start out with, gets it completely wrong. Right? He's not being asked to determine anything about management. But as it turns out, so that's his sort of provisional reasoning, because he's not finalized it as yet. Now, if you look at I'm not going to take you to it, but the references at 363, you will see the listing of the court's content, and you will see that none of it's all management, human resources management. There's nothing outside of that. So then what happens afterwards is the PS responds saying she has no objection. And then the CPO responds on 436. And the CPO says that...
have you got the page number for the PS's response?
That's EB 436.
It is 436, okay.
Yes. Well, the PS's response, the PS's response is at 364. She simply agrees. But the Chief Personnel Officer is at 436. And his response is more focused on the actual regulation. And this is what he says. He says, I refer to the correspondence on the above. After a thorough examination of all the information submitted, I advise that the postgraduate diploma in human resource management from the Arthur Lockjack Graduate School of Business cannot be considered as an equivalent related qualification in accordance with Regulation 1B, as it does not address the technical aspects of the job relating to firefighting and the fire service. Then he says, notwithstanding, and in light of this, we would have no objection to him being exempted from the management studies course at Regulation 8.3. So he gives now the Court of Appeal is critical because he says, critical of this. They say he speaks cannot be, and he's binding the Chief Fire Officer. But it's worth noting that the reasoning of the Chief Personnel Officer is absolutely clear and it's absolutely logical. And even now, Mr. Green does not suggest in any way any rational basis upon which his management qualification could realistically be substituted for the fire services qualification. The reasoning is unassailable on this issue.
What's a little odd is that the memorandum isn't addressed to the Chief Fire Officer, it's addressed to the Commission.
It is, but then...
The Chief Fire Officer who is to make the determination in
Well,
relation to equivalence.
So the chief fire officer does make the determination. So it gets to him, and you will see that the chief fire officer is at 444, and this is the determination that is not disclosed by...
Just before we leave 436,
Yes, my lord.
seems to be addressed to the permanent secretary.
Yes.
So it goes, as it were, fire officer.
The fire officer has to consult
Permanent
the
secretary
PS.
doesn't disagree. Then it goes down to the CPO. He sends it back to the permanent secretary.
That's right.
So it's going back up the chain.
It goes back, but there's no question that the chief fire officer does get it, because you'll see the reason.
Oh, sure.
Yeah.
Yes.
So this is all within the executive branch of government, all within the department.
Yes, that's correct. Now, so 444 is the determination on equivalency.
This
that
is the
made.
letter of the 11th of...
This is 11th May 2007. Yes. Now, so this is the actual determination that is made. It's addressed to Mr. Green, and it's from the fire officer. And it says, it echoes the reasoning of the CPO. It says, it can't be considered as equivalent. It doesn't address the technical aspects of the job related to firefighting. And then it says, notwithstanding that they've exempted you from the management regulation, which is not an issue in the case. But now,
Was this the determination that the PSC itself had regard to?
well, my lord,
There seemed to have been some question in the Court of Appeal's mind about this.
it is raised downstairs, and the Chief Justice in the Court of Appeals suggests, well, it's not clear that this is before them or not at the time. But what I would say is that because of the way the case was framed in a way that said, not that I had a determination of equivalence. That's not what he says. What he says is, I have an equivalent qualification, as though it was for the Service Commission to determine equivalency. And that's what he asked the court to do. He says, I had the equivalent, because look at all these qualifications I had. His case is never, I've got a determination from the Chief Fire Officer saying it was equivalent. Right? He says, by virtue of having these qualifications, I have equivalent qualifications. He never produces an equivalency determination in his favor. And that's an important point, because really, that's really all the Service Commission could look at. Because it's either you have the qualification or you do not.
The Court of Appeal was very concerned about whether the PSC had in fact taken the view of the Chief Personnel Officer as determinative of that question.
I know, and my lord, that is a completely misplaced approach, with great respect to them, because it's not even for the CPO to dictate. The Service Commission can only decide you are eligible if they have a decision of the CFO after consultation. And not even Mr. Green he didn't even produce one in the case that he brought to court. All he brought was a provisional view of the CFO before he consulted. So that's why I said at the beginning, as a matter of fact, in this case, on the state of the evidence, even now, there is no determination of equivalency in his favor that has ever been made. And this is taking into account everything with Mr. Skeet coming and saying, I never authorized that letter. Even taking all of that into account, there is no determination of equivalency. Even now, he doesn't have it. Which is why I said the case could not get off the ground with respect. Because the Service Commission was
to understand is are you saying that the board should approach this matter on the basis that the PSC had regard to this memo of May 2007 as expressing a view on equivalency?
My lord, I'm saying that the board should find that the claimant, or Mr. Green, has never produced a determination that he had an equivalent qualification. And therefore, he could not have been eligible. This document is relevant because it shows non-disclosure, and it shows a breach of his duty of candor and all of those things. But even if you were to ignore this document, he has no determination of equivalency in his favor. And that really, not to be glib, but that really is the end of that. Because at the end of the day, when the Service Commission has to make a determination, they have to go through a list. Have you complied with 8.1a? Have you complied with 8.1b? Have you complied? And if you don't have a letter from the CFO saying this is equivalent, then that's the end of that.
But I find that approach troubling because the Court of Appeal was very exercised by its view that the PSC had taken the view of the opinion of the CPO as to this question of equivalence. And in a number of passages, it emphasizes that the CPO had no decision-making process in the entire exercise. That was the reason why the court below was wrong to pay attention to the CPO's determination.
The court, at first instance, some of the language that is used in the passage says CPO, and I think that might have been an error in the judges, simply in recording the decision.
The first instance judge.
The first instance judge. But the fact of the matter is, on the facts of the case, the only decision that the Service Commission can take into account is a determination of equivalency made by the Chief Fire Officer.
You say in paragraph 23 of the first instance decision that it's an error?
Yes. I do think
reference,
that was not
reference
what was
to the
argued.
decision of the CPO should be a reference to the decision of the CF.
The CFO, yes. Because otherwise it makes no sense, because the CPO is, the only input of the CPO in this process is in the consultation. And it comes back to the Chief Fire Officer at that point to make a determination. Now, the Chief Fire Officer is not a defendant.
You're going to take us at some stage, aren't you, to this signature on page 444?
Yes, I am.
Okay, well, I'll
Yes.
I'll keep my mouth shut.
Your case is that a determination by the Chief Fire Officer that the qualification was equivalent is a sine qua non
It is.
of any finding of eligibility.
That's right. And that's a distinct question from his determination that it was not equivalent.
Yes.
Even if we don't get into this,
Yeah.
there is never a determination that it is. So, and the fact that it's a sine qua non is because the regulation says so. And at the end of the day, the Service Commission can only apply the regulation. So it's very troubling that we are criticized for what we did, when on the state of the evidence, it is clear that he could not possibly meet the eligibility criteria. Now, what is relevant is that after this happens, Mr. Skeet. Now, Mr. Skeet comes and gives evidence in the case, and I'll take you to. Well, perhaps I can take you now to what Mr. Skeet says. You know, he says, "Oh, I never authorized this document, etc." And he's very critical. But it's a 461 is the relevant paragraph of his affidavit. The relevant page of the bundle. And he says, well, with respect to the Gopal affidavit, I say that the letter was written on my behalf by John Edwards. Right? So he says it's written on his behalf by John Edwards, and I think we pointed to in the fire service there is a delegation power, like a Kaltona power is expressly codified in the Act. But this is what he says, and it's important to read this with some detail, because it doesn't quite say what Mr. Green thinks it says, I suspect. What he says is, I never authorized him to inform the claimant that his graduate diploma cannot be considered as an equivalent related qualification. He then says, I consider the qualification to be equivalent related as I considered Mr. Bruce's qualification to be such, right? There's an issue, Mr. Bruce was appointed many years later. He then says, and this is the important part, I have made the observation the letter was signed by Mr. Edwards on my behalf. It was not signed by me. Again, not relevant, strictly speaking, because it's never been challenged. It's a determination on the record. My instruction to Mr. Edwards in writing, informing him that his postgraduate diploma was accepted as an equivalent related qualification, and according, he was exempted from the management studies examination. So there's a lot of confusion in what Mr. Skeet is writing. It mirrors his confusion in the first place, in the very first memo, where he seems to think that he's considering equivalency to the management qualification, which he... forgive me. The earlier one is not Mr. Skeet, I'm being told, but it mirrors the confusion in the first CFO memo, where remember, my lords, I pointed out that he was not determining whether it was equivalent to management. He was supposed to be determining whether it was equivalent to the fire engineering qualification. And even then, at this point, when Mr. Skeet writes his affidavit, he again confuses it. He says, that's not me, my instruction was that it was equivalent to the management. Again, not what we are discussing. But in this same affidavit, if you turn the page again, it is relevant. If you look at the exhibit, Mr. Skeet's first exhibit that he does authorize, and this is important because this is the 24th of July, 2007. He says...
And what's the electronic bundle reference?
464.
Thank you.
My lord. Now, in 464, which is taken after the decision of the CFO, that Mr. Skeet, says, I never authorized. This is what Mr. Skeet says, and he says this is his document. He says, the Chief Personnel Officer advised he had no objection to Fire Station Officer Green being exempted from writing the Management Studies examination at Regulation 8.3, which is true, based upon him attaining these various courses. Acting Fire Station Officer has now submitted an application asking that his postgraduate diploma in Human Resource Management allows him to be exempted from writing the management examination to the rank of Assistant Divisional Fire Officer. That's a rank two ranks above. And then he says, I've assessed it and now I've exempted him from that. But the point being that even after these determinations are made, and even after the CFO, he's had the CPO's view as to equivalency on it being equated to management only and not the fire engineering management, Mr. Skeet is receiving applications again about other management exemptions, which can only mean that Mr. Green accepted the determination that was made about not being equivalent to 8.1a, but allowing him to exempt other management, and thereafter made another application for an exemption to Mr. Skeet. And the relevance of that is that it underscores the fact that there's never a challenge to the decision that was told to Mr. Green that he did not have an equivalent qualification. And you don't get to avoid that a decade later by putting in a confusing passage from Mr. Skeet about what he authorized and what he didn't authorize. At the end of the day, the fact is you concealed an express determination that it was not equivalent. And frankly, the Court of Appeal takes an altogether too sanguine view of that act of non-disclosure, which on its own should be equivalent for the claim to be dismissed, in my respect. It's difficult to conceive of a more important document in the case that should not have been brought to the attention of the court by the claimant. Now,
and that's 444 was the document that was not drawn to the attention. That's the letter of the 11th.
Yes, my lord, yes, that's correct.
Can you just help me? I thought I'd understood the procedure is that when there's to be a promotion round, the Chief Fire Officer sends a list of eligible persons
Yes, my lord.
to the PS.
So that's the eligibility. That's the second decision, which I would get to now.
Well, all right, but just let me set out what my provisional understanding is and tell me why I've got it wrong.
Of course.
One wouldn't expect the Chief Fire Officer to include on that list someone he didn't consider to be eligible. And therefore, the PSC, when it gets the list, isn't, as it were, looking to see whether somebody who's not on the list is somehow eligible because he's got an equivalent qualification. They just don't consider him because he's not on the list.
Well,
Conversely, if he is on the list, why do they have to reinvent the wheel to work out whether he's qualified?
Well, that's
the
what
Chief Fire Officer is putting him on the list.
That is what Ramsaran deals with, and I'll take my lord to that when I get to the section of the Public Service Commission regulations. But what Ramsaran essentially says, and that's the most recent decision on this point, is that the Chief Fire Officer can recommend, but it's absolutely clear that his recommendation as to eligibility cannot bind the Service Commission. They must exercise their power. So if he's left somebody out, they have to determine And presumably if he's put somebody on, they also have to check and make sure that he meets the
But
eligibility.
how if he's left somebody out? Do they know the person's there?
Sorry?
I had perhaps naively assumed that what the PSC does is go through a list that's been put in front of them.
Well,
Not go around all the fire stations in the country to find out whether there's somebody else potentially eligible whose identity they have not been notified.
Well, I don't think that they go around to the various fire stations, but there is a central repository of records, and that is part of I suppose, the importance of the CPO's office as well.
Well, I'll certainly be assisted by getting some better understanding than I have at the moment.
Yes, so let me. This might be a helpful moment to get to that.
Just before we do, to follow on my Lord Briggs's question, putting aside for the moment the question whether that list might bind the PSC, I don't think anybody would suggest that it could. Wouldn't it at least implicitly suggest that the chief fire officer considers the person to have had the necessary qualifications
So that is
in order for them to be eligible for consideration?
So that is.
And in this regard, of course, I think we are now looking to the 2013 list,
Yes.
which was the operative list.
So that is the point that the Court of Appeal raises.
Yes.
And they say, well, isn't there a determination, an implied determination of equivalency? Again, not the case that was raised. Again, so it's again a departure from the pleaded case. But the point is that what we say is that that list itself it's helpful to turn it up. I'm just trying to find the reference to it.
This is the one with Mr. Green at number 9, isn't it?
Yes.
Yeah.
That list.
Page 429 of the electronic.
So the first point is that under the regulations, and I was going to come to this after, but we can deal with it now. It's not for a merit list to be promulgated by the chief fire officer. He is to put forward a list of eligible persons, who he recommends and who he does not recommend. That's what the regulations envision. Now, if you look at the list, this is what it says.
Sorry, the list or the note?
Well, so I'm looking at the cover letter first,
Yes.
the note, then 429.
Yeah.
And you see that it says, encloses a list of fire substation officers who qualify for promotion. So I suppose that should be read as eligible.
Yeah.
Then he says, also encloses a list of fire substation officers who have acquired the Joint Services Staff College qualification. Now, if you look at the list itself, which is on page 430.
430?
Yes. You will see that it's headed List of Fire Substation Officers who have passed the Fire Station Officers Examination and Graduate Institute of Fire
I'm sorry,
Engineers.
we're going to page
430.
430.
430.
Yes.
It's in landscape.
Yes,
Yeah.
I've got it. Mr. Green at number 9.
So if you look at the top of the list, you will see that it says List of Fire Substation Officers who have passed the Fire Station Officers Examination and Graduate Institute of Fire Engineers, GIF, they put it. Now, Mr. Green is on the list, and he is the only person on the list who has neither the FSO examination or the GIF. What he has instead is a listing of various other qualifications. Certificate in Human Resource, Certificate in Public Relations, Postgraduate in Human Resource Management, etc. Now, the question is, that my Lord has raised is so first of all, I don't think it too much turns on it, whether it's a merit list or not. Because it says merit in the first column, but of course the regulations don't require a merit list to be promulgated. It simply requires him to say eligible persons he recommends for promotions or eligible persons he doesn't recommend for promotions. He does not appear to have put a list of persons he did not recommend. It's just a list that is put forward. And there's a second list also.
Before you move from this list, there's eligible column, or column headed eligible. And there, in respect of the respondent, he notes 2006.
That's
Can you assist us as to the significance of that note?
Well, again, no one should be on this list at all unless they're eligible in some way.
Yes.
And the CFO is required to make a list of who he considers to be eligible. Now, it is the question that my Lord raised. Now, the way I say this should be looked at is that he has to make a recommendation of who he thinks the eligible people are and who should be promoted. But the Service Commission itself has to satisfy itself that people are eligible.
Yes.
Meaning that if he has included somebody who as being eligible who is not, that does not bind them. And that's what Ramsaran says, that they have to satisfy themselves. The question that's been teased out by my Lord is, well, should we read this as being a determination of equivalency so as to justify it's his inclusion on the eligibility list? And we say that in construing that, one, it confuses two separate determinations that have to be made. One is, it's not just for the CFO to determine equivalency. He has to consult with two persons before he does it. That's the first point. Secondly, that decision itself is based and moored within regulatory requirements. It's not just what he thinks. It's actually based upon the fact that there is something that could possibly rationally be equivalent to the Graduate Institute of Fire Engineers determination. Thirdly, there is...
What was that second point?
That if he is determining that it's equivalent, it has to be on a rational basis. That if there was a qualification that said, American fire engineering diploma, you could see an argument maybe he has determined equivalency because of the fact that it's there. But the problem with taking what we say is the wrong approach of the Court of Appeal and saying, well, shouldn't you treat this list as a determination of equivalency in the face of an express determination that it was not equivalent? When an application was made, the application's never revisited. There's no evidence that Mr. Green ever says, will you reconsider this decision? There's no evidence of any of that. What we know is that he took the determination, applied for a management exemption, and did nothing else. He didn't judicial review it, he didn't revisit it. So the problem with treating this as an equivalency is, well, first of all, which qualification is supposed to be equivalent? Is it we just supposed to guess that it's, because it says 2006, that it's the management of human resources qualification?
Mr. Das, you started by saying that the Court of Appeal had confused two matters, and I didn't understand what the two matters were.
The point being that there is a determination on equivalency that has to be made by under Regulation 8 if somebody applies for a particular credential to be considered to be equivalent in order to be eligible.
Decision as to equivalence in an individual case?
Yes.
Whether it's satisfied?
Yes. So that application is made, and we know that it was refused. And and there is a specific modality. You have to consult with two persons, the public service, the permanent secretary, and the chief personnel officer. That's what Regulation 8 says. So there's a modality of consultation, and as a result of that consultation, a determination is made that it is not equivalent.
Yeah, and what's the second thing?
And that's never challenged, it's never reviewed. The second decision is whether somebody is eligible to be promoted to the next office. Meaning, do they have all the relevant qualifications that they're supposed to have? So, for example, they have to, in the first place, they have to be a fire substation officer. Then they have to have a management credential. Then they have to have, then they also have to comply with 8.1, 8.1a, or 8.1b. Those are all matters that the Service Commission must determine whether someone is eligible. They look and see, well, have you checked all these boxes?
Well, is not one way to read the list, taking the document as a whole and looking at it alongside Regulation 8.1, as setting out, just going back to 8.1, that there are three ways, as I see it, you can get through the 8.1 hurdle. One is you've passed your job-related written examination under A.
Yes.
Which I think is what they call the FSO exam.
That's correct.
Don't they? The second way is you've got the diploma, and that's what they call a GIFE, G-I-F-E.
That's right.
And the third way is that the Chief Fire Officer has determined, after consultation, that you have something which is equivalent to the diploma.
Yes.
One way to read this is that where it says past FSO, they're saying, well, they've got through 8.1 via Gateway 1, or Gateway A, if you like. Where they say it's a GIFE, he's got through the gateway under the first part of 8.1b, got the diploma. And where you see a whole list of qualifications listed, and neither the FSO exam or the diploma, wouldn't one interpret that as meaning that he's got equivalent qualification, noting in particular that two of the qualifications post-date the 2007 letter.
Well, my lord, that is certainly...
And I'm putting a case to you not because...
Yeah, I understand, my lord.
Just get your submissions on it.
Yes. Well, our position on it is that one, remember, we are a public authority, and what we do will impact others. We have to treat everybody fairly. But that if we're letting in somebody with a human resource management qualification, then we're going to meet an argument later on about other persons who have simply been put on a list now being treated as equally, and the dangers of bypassing the specific regime under Regulation 8 for consultation and specific determination, so that it cannot lightly be departed from. Secondly, we also have a wider public interest to the public at large and the safety of the public at large. And there is no public interest in having a cadre of officers who have no fire service qualification but have extensive management qualifications only, specifically where the regulations require a management qualification and fire service qualification. That's what 8.1 and 8.2 and 3 require. They're separate topics of qualification. So one has to be particularly careful in sort of glibly saying, well, maybe these management ones are enough to cover the other. And
I'm not putting you to that they were.
yes, I understand.
But that a reading of this list,
Yeah.
taking full account of the heading which describes them all as being qualified,
Yes, my lord.
might lead the reader in the PSC to think that the rather long drawn-out description of Mr. Green's qualifications was a way of saying that he'd got through by virtue of there having been determined in his favour an equivalent related qualification. Not that it's right, but that that's what the document appears to be telling the PSC.
Well, yes, my lord, and that's why I was drawing a distinction between the procedure under Regulation 8, because if you had made a determination of equivalency, there would be a consultation procedure with two sets of people, and a decision that was made.
Well, if this point is right thus far, that's what it's saying, namely that these qualifications add up to something equivalent to the diploma. One would naturally read the document as saying by implication, and of course in reaching that conclusion I've consulted with the two people I have to consult with, namely the Permanent Secretary and the Chief Personnel Officer.
Yes, my lord.
Without having to spell that out in the document.
Well,
that will be taken as omnia praesa muntur rite esse acta.
well, except for the fact that all of these documents and the fact that there's a determination in any event on the file of Mr. Green telling him that he doesn't have an equivalent qualification. And there's been a response from the CPO saying that it's not equivalent. And on its face, it doesn't appear to be equivalent at all.
No, it doesn't. But in this regard, to suggest, perhaps we should look at paragraph 125 of the Court of Appeals judgment, to set electronic bundle, page 176, because we are now speaking about 2013, some 6 years after the memo of May 2007.
Yes, my lord, and it's significant that the CFO at that date
gives
evidence.
That's a relevant date, isn't it? Because it's a recruitment process in 2013, which began in 2010.
Yes, my lord.
And the Court of Appeal was concerned that since 2007, Mr. Green had acquired further relevant certifications, which they have listed in that paragraph.
Yes, my lord.
And which they seem to be, of the view, might have been considered by the CFO in 2013.
Yes, my lord. But the point being that there's no evidence that Mr. Green ever applied for a determination of equivalency for those qualifications. And that's the point I was making at the beginning. He never asked them to revisit it, either by saying the first one was wrong, or by saying now, by virtue of having new qualifications, should I now be treated as being equivalent?
That may well be so, but it does not address the question whether or not the CFO had considered them and might have considered them in determining eligibility for the purposes of this list.
Well, my lord, the CFO at the time is Mr. Bruce and Mr. Gopal, both of whom give evidence, and neither of them suggests that they made any such determination at all. And neither did Mr. Green ever suggest that he had ever obtained such a determination.
Did the CFO responsible for this list explain why Mr. Green's name was included on it?
It is not.
Did not.
He was not, as opposed to the Ramsaran decision, in which the CFO's decision was challenged. The CFO was not a defendant in the case, and so there was not an explanation, or at least not a satisfactory explanation. I don't think there's any explanation at all as to why he's on the list when properly being he should not be there. But what we say is that in the round, when you look at it, it doesn't appear that there was a specific determination. There's no explanation for the date in 2006, which is the date that list says he's equivalent from. My lord, you drawn my attention to that. Which seems to be that it predates, in any event, the latter qualifications. But most importantly, there's no evidence that he ever applied for it. So if he was applying, then where was the consultation that had to go through? There's no determination. This is not a case in which there's even a suggestion by the CFO that he made this determination at all. This is an attempt to tease out of a list that we know doesn't bind the Service Commission on eligibility a determination on equivalency that is a quite important determination to make, because it goes to the technical qualifications for an office. And that determination should only be made with some considerable care. So we say that it is wrong, as a matter of fact, to read into the grant of that list of the fact of there being some sort of de facto determination of equivalency, particularly in light of the fact that there is no technical qualification at all, and there was an express determination, and an entirely correct one, we would say, that the management qualification could not be treated as equivalent.
So you effectively say this is just a mistake on the list. It's a bit of a mystery how it got there. The date given, crucially as to eligibility, is 2006. So it can't be anything to do with some sort of later qualifications now being taken into account. We have a clear indication in 2007 that the CFO was not regarding this as eligible, and that's it.
Yes, my lord. And on that basis, you couldn't... Can I just have one moment? No, sorry. And Ms. Torsey's just reminding me that in recounting the history of what happened, the chief fire officer at the time, Mr. Gopal, does give evidence, and he doesn't suggest that he ever made any of the determination at all of equivalence. In fact, he refers to the earlier determination that it was not equivalent, and he's there in 2013. So
well, he was in post from when?
I will get this specific date for you. No, he's 2015. Yes, that's no. Forgive me. That is wrong. What I said. He was in 2015. He was the chief fire officer in 2015.
He's a bit later.
But he gives an affidavit, and he says that when he produces the records, what he produces is the refusal in 2000.
Is what he produces? I'm sorry.
Is the refusal of equivalency in 2007. That's what
The refusal
of equivalence.
equivalent.
Meaning that there was no later application for a fresh determination or a revisitation, and there was no decision of equivalency ever made.
Can I just pin you down on exactly what bit of 8.1b is binding on the PSC? Your general position, as I understand it, is that there's been no challenge to the regularity of Regulation 8,
My lord, A1B, so,
81B.
or 81B, yes.
444. No, it's actually on page 1192. 444.
Yes. Now,
I just want to pin you down on where it says as determined by the chief fire officer. Are you suggesting that that is not a determination which is binding, or are you saying a determination that one exam or qualification is equivalent with another in the abstract is binding, rather than a determination about whether a particular person can take advantage of it?
no, that's not precisely the divide what we're saying. What we're saying is that a particular qualification, it seems, can be treated as the chief fire officer can treat a qualification as being equivalent, so that conceptually it could be for a different applicant.
It's about exams rather than people.
So that
That's I think, how I would read it.
Yeah, that's my understanding.
And that determination, as I understand it, is binding.
Yes, it is. In our written case,
Subject to explosive rationality.
we suggested it was not, and I think Mr. Knox had said, well, he differed from us on that. But I accept that it is binding. It must be, because otherwise they wouldn't be vesting a specific discretion in the chief fire officer. If he makes a decision on equivalency and any fire officer doesn't like it, they can presumably challenge it and say, well, you should have treated this as equivalent because look at the content, it's irrational, etc. So that the question, it's not related to a person, it is related to a qualification.
Yes.
So he can say this degree from, whatever university, that's equivalent, and I'm going to treat it. And then everybody else, and this is the important about...
And that would be binding.
Yes. And this is the point that's important, because that then informs all the other officers. Because then they can say, well, instead of getting the GFO, I can get this one. Yeah. And that's why we can't be a bit too glib about saying, well, let's just fill in particular qualifications, because then it affects everybody else. And so there has to be some measure of care, and that's why there's consultation, and that's why it's a discrete decision that's made well before eligibility for promotion arises. In fact, it could have been made before in respect of another officer, and other officers could be simply claiming the benefit of it because of a decision that was made.
And you presumably also say that it's looking for a particular equivalent related qualification rather than the aggregate consequence of having got 8 different ones which together get you over the
Exactly.
hurdle.
It's a particular decision of a particular qualification that has ramifications for the fire service in future.
Yeah.
But an equivalent related qualification could be, in a particular case, a number of qualifications. A number of different qualifications.
Well, I suppose
be equated.
Yes, but it would still be qualification.
Specified.
It would still be qualifications. You would say, if you have this degree, and this degree, in aggregate, I will treat that as... I have no difficulty with that conceptually. That must be correct. And again, if anybody was unhappy with that decision, they could challenge it on a rationality basis, just as Mr. Green could have challenged the refusal that he got. So, but again, this is an anterior decision that is made. It's nothing to do with eligibility. Eligibility is checking what happened in the past. What qualifications did you have? So, the point in I'm
just puzzled in understanding why Mr. Green appeared. You're really saying he's on this list by mistake?
Well, we didn't prepare the list.
No.
But yes, he doesn't qualify. He cannot qualify. And even now, on the state of the full evidence, there is nothing to suggest that he qualifies, that he should qualify.
And the Court of Appeal relied upon it essentially as being an implied determination or evidence of an implicit determination. But in order to look at the document and interpret it, one's got to look at the whole context and background as known to the time of the consideration. So a person looking at it would know that in 2007 there had been an application and a refusal.
Never revisited.
That wouldn't square with him being eligible in 2006.
And that's why, it's my client, but I have considerable sympathy for the approach that they took. Because they simply said, when we go through the list, you don't have it. Everybody else has it. Imagine how unfair it is if we allow this person to be promoted when everybody else has complied with the list. It would be, an extraordinarily unfair thing to do. Now, my lord, the case of, now the regulation, under the...
Just going back to the
list, yes.
the eligibility is stated as, or appears to be stated as from 2006.
Yes.
Some of the qualifications, or at least one of the qualifications is obtained in 2009, so it doesn't seem that is
Well, this is
something which is...
and that's the point. I think my Lord Smelly was raising that, about whether the qualifications have changed, and the Court of Appeal suggests that. But there's no suggestion. The list suggests it's at 2006, but also the evidence suggests that he never makes an application in respect of those, because you would still have to say, the court would have to say, from a fair reading, we've concluded that this qualification was treated as equivalent.
And I mean, it looks as if the date of eligibility is a very important part of this list, because if you like, your position in the pecking order depends entirely upon the date when you first became qualified for promotion. But the dates proceed chronologically through the list, don't they, starting in 2005 and ending in 2012.
Now, the eligibility decision is done under the Public Service Commission regulations, and those are found at electronic bundle 1368. So it starts. The relevant part starts at 1365 of the electronic bundle, and that's part 2, and you'll see it's headed Appointments, Promotions, and Transfers. So that is the rule book for the Service Commission, so to speak. And what it says is, at Regulation 151, this is at 1366. How much time? The Chief Fire Officer shall advise the Director of a vacancy within 14 days of the vacancy occurring, and then the Director will, by circular memorandum, invite applications from eligible officers. At 153, it says, and this addresses the point I think my Lord Briggs had raised, 153 says a failure of an eligible officer to apply does not debar the Commission from considering it. So they have to have an overview at all times. Then at 158, this is the relevant power of the Commission. In considering them eligible fire officers for promotion, they take into account experience, educational qualifications, merit, and ability. So that's the general broad-based merits power that they exercise. But at 160, if you turn the page to 1369, you will see the power of the Chief Fire Officer. And what it says is, where a vacancy occurs, he, taking into account the 158 criteria, meaning so he must express a view on what they have to do. He will then send them a list of the officers he recommends for promotion and a list of officers who are not considered for promotion. And just for the sake of completeness, if you look at 162, and he has to, if he doesn't recommend somebody, he has to tell them, and then they can make recommendations themselves. That doesn't occur in this case, but it's just to show that they are not limited. Now, in the Ramsaran decision, that is at 1505 of the bundle, and that is the most recent case.
Page, sorry.
But the case itself starts at
1505.
Yeah, the case starts at 1493, and the relevant part for this point is at paragraph 47, where they say, well, they define in paragraph 47 what eligible officer means, which is what the Service Commission has to do. And they say that it means a fire officer who satisfies the qualifications of an office. And the qualifications of those, well, in this case, it was a different post. So it's Regulation 9. In our case, it would be Regulation 8. But what is relevant is that at paragraph 58, you will see that they deal with this point. This is at 1508. Mr. Pennington Benton, who I believe appeared for the Commission, he said that only a person recommended for appointment by the CFO could be appointed by the Commission, and he linked it with representations, etc. Now, that's a slightly different provision, but the reasoning of the board on 159 is relevant. He says the board does not accept these submissions, which cannot be reconciled with what the regulations provide. The structure of the scheme has to be borne in mind. The commission is the body responsible for making an appointment. The CFO cannot control the commission in the exercise of that function and has no power to exclude any eligible officer who applies for a post from being considered. And then the CFO only has a power to make the recommendation as to whether a candidate should be appointed. On the other hand, he's in charge of the service, and this is because under those regulations, there was a power to petition the CFO. But the point, the core reasoning of that must apply as well to 158, which is that, of course, the chief fire officer is entitled under 160 to express a view and a recommendation, he must look at what the commission is to do and he must give a view on it. But of course, the commission cannot be bound by what he says. They have to consider it afresh and they must look at the evidence objectively.
But they're bound by the determination
of equivalency.
They're not bound by anything else in relation to...
So if, for example, the chief fire officer overlooks the fact that somebody doesn't have an equivalent qualification and is therefore mistakenly considered to be eligible, they are not bound by that. But if there is a specific determination of eligibility following the prescribed modality of consultation, they are bound by that. And our respectful submission is you cannot elide those two functions. And it's wrong to read out of that list in 2013 anything that suggests that there was equivalency. It's certainly not in the public interest to do it. My Lord, I don't have very much time left, and I wanted to...
Well, I had one eye on that. Mr. Das, it's open to you to use up some of your time in reply if you want to.
Maybe I will just to deal very quickly with the... I just want to touch on the natural justice point and on the joinder of the Attorney General point, which I can deal with more quickly. In Ramsaran, on the natural justice point, what we say is that there is nothing unfair about someone being required to meet the requirements of a prescribed regulation. If on the other hand, there is as happened in Ramsaran at paragraph 64, what happened in Ramsaran, and that's it for your note at paragraph 1509, what happened in that case is there was a job description that said that there was an experience criteria that was required. And in fact, the commission was treating that as mandatory. You had to have it. And the board pointed out it never said it was mandatory, so that it was unfair to treat it as mandatory. And really, that's really just an articulation of the secret policy cases, meaning that if you have a policy as to how you're going to administer something, it's unfair for people not to know so that they can tailor their case to meet it. But that doesn't apply at all when we're simply dealing with a prescription in a regulation that everybody knows and can therefore fairly have a chance to meet. Meaning if you had a determination of equivalency, you put it forward. If you had a specific degree that they said was equivalent, you took that particular degree and you submitted it. And that would be enough. You can't complain if you don't comply with a prescribed mandatory qualification. So that, and Ramsaran illustrates that very clearly. On the point of the AG being a party, this was not raised in the case below. It is routinely done that the AG is joined where constitutional motions are claimed. In fact, if you look at the same Ramsaran decision, which is the most recent case involving the same parties in a sense, if you look at Lord Sales's judgment at page 1495, you will see that the paragraph 2, the head of the service is the chief fire officer, the first respondent. The Public Service Commission, my client, was the second respondent, and the Attorney General, the third respondent, has been joined in the proceedings to represent the state. And if you look at paragraph 4, you will see the reason why. The appellant seeks relief by way of judicial review, and he brings a constitutional complaint claiming that his rights under Section 4B have been breached. And that is routinely done in Trinidad on a mixed claim. It's surprising that the Court of Appeal did not recognize that. It is also the subject of binding authority, which is the decision in Carmel Smith, which is, in which this very point was raised. And what Carmel Smith says is that, and that's at 2215, Yes, 2215, is that because Section 14 of the Constitution says the State Liability Act applies, and because the State Liability Act specifically refers to service commissions under the Constitution named under Section 3.1, which is what the Public Service Commission is, then the effect of that is that if you look at paragraph 15 of Lord Walker's judgment, you will see that he says that the effect of that is that 222, sorry. Yeah, what he finds is that the effect of the State Liability Act is that in the last paragraph, their most important practical effect is that judicial review proceedings may still be brought, despite Section 19.8 and 9 of the State Liability Act, against any of the service commissions in its own name. But they do not have that effect in relation to a motion for constitutional relief under Section 14 of the Constitution.
I'm so sorry, which paragraph are you in?
I'm reading paragraph 15 of Carmel Smith.
Thank you.
Yeah. And that is the, and the reason for that is that, if I can just give you the references, Section 14 of the Constitution says in 14 that the State Liability Act applies, and the State Liability Act, which is at 1381, provides that proceedings against the state shall be instituted against the Attorney General. And then it says, proceedings against an authority established by the Constitution or a member in connection with the exercise of powers in its functions are deemed to be proceedings against the state. And then 19.9, this is at 1398 of the record. Authority means the Service Commission as defined under Section 3.1 of the Constitution. The Public Service Commission is named under 3.1 of the Constitution. That's at EB 818. And that was, just to be brief, that was the effect of Carmel Smith. That was what was argued in the case.
Could you just refer us to those sections, the numbers of the sections again, please?
I'm so sorry. I was just trying to move perhaps too quickly. So section 3, hold on. The State Liability Act is at 1381.
Yes.
And the relevant part of that act is Section 19. That's at 1397. And it says in 19.2, subject to this act, proceedings against the state shall be instituted against the Attorney General. And then in 19.8 and 9, this is on 1398, it says proceedings against an authority established by the Constitution or a member arising out of or in connection are deemed to be proceedings against the state. And then in 9, it defines it. Authority means a service commission as defined in Section 3.1 of the Constitution. The Public Service Commission is defined under Section 3.1. That's at page 818 of the record.
Thank you very much.
And the State Liability Act is expressly incorporated under Section 14 in the grant of constitutional relief. And that's what Carmel Smith decides. That's the point. And that you had to, when you sued the Service Commission for breaches of constitutional rights, you had to name the AG, but you could judicially review them in the ordinary sense. And that point was again reiterated in Achille Charles quite recently, in which the converse happened. There was a criticism of the JLSC, and they said, well, look, you didn't join us, and it was unfair. And the Privy Council said, you are only required to join the AG. You're not required to join the JLSC. So they softened the language so that it was not critical, but they said the findings against the state were only required to be made against the Attorney General. Now, so there's a lot of law on that. It's been quite well settled. And that's why in Ramsaran, what is traditionally done, if you wish to pursue constitutional damages, you join the AG and you bring the claim as a composite claim against both of them. Now,
are you saying that's what's routinely done, or are you saying it's incompetent not to do that?
I'm saying it is routinely done, and it is wrong to have damages or to have relief under Section 14 without the AG as the defendant being notified specifically. It is also, we also put into, and that's what Carmel Smith said, and a number of cases have said it, and that seems to be a specific choice that was made under our regime. Under Part 56, my learned friend, Mr. Thompson, points out that under Part 56 in judicial review claims, you serve the Solicitor General. But it's worth noting that even under the civil procedure rules, if you're bringing a motion, a claim for damages, it's treated separately under Part 56, which is claims for administrative orders, and it is served separately. To tell you the reference very quickly.
Do you say that as a result the court had no jurisdiction?
So what can happen is that before you rule, you could ask the AG to be joined. And there's no detriment in doing it before. But not just for damages, because the case of Allain makes clear that the grant of redress under the Constitution includes declaratory relief, or whether you should have constitutional relief at all, that's what redress is. And the AG is entitled to be heard on that. So that at some point, before determining the case, it's clear that you could have joined the AG. But this board has noted, for example, that the jurisdiction of the High Court under Section 14 is original. It can't be exercised even by this board. It has to be invoked properly before the first instance court. Hunt was the case where persons were incarcerated for more than 5 years on death row by the time their appeal came up, and they asked the board to simply grant a declaration under the Constitution that they could not be executed, the Pratt and Morgan ruling. And the board said, no, you have to invoke it at first instance, because it's an original jurisdiction. The board only exercises an appellate jurisdiction. So you have to comply with the modalities of Section 14. Before I answer that question, I was just pointing out that under the civil proceedings rules, which is in the supplemental bundle, that's Part 56, which deals with 3 types of claims: actions for declarations, judicial review, and claims under the Constitution under Section 14. And there's some differences. So you only require leave for judicial review. But when you do get leave and you issue a fixed date claim form, you have to identify if it's a claim for judicial review or a claim for or an originating motion. And under CPR 5610, for example, a motion is served on the AG. But under 5610, where the AG is not a defendant, you simply give notice to the Solicitor General. So they've always maintained some slight differences between them. But now, part of the relevance of that is that, of course, a public authority may not be under the control of the central government. You might have an opposition-controlled local government department or a quasi-public body, for example, so that there is some relevance for including the AG if you are making a claim. But what we would say is that, just as a matter of principle, it should arise because the Constitution requires it, and that's what Carmel Smith and these cases have maintained. My Lords, I think I've passed over my time. Can I just ask, is there anything? Well, Achilles Charles is at 1414, and Allain is at 1435, dealing with what redress is under the Constitution.
1414 and
1435.
35.
Yes, 1435. My Lords, unless there are any other questions, we of course rely on our written submissions, and I adopt what my learned friend's case for the interested party as well.
Thank you, Mr. Dash. We're grateful.
Thank you.
Mr. Knox.
My Lords, there are 4 issues I wish to cover. The first is, briefly, the natural construction of Regulation 8. The second is, does Regulation 8 on a natural construction comply with the Constitution? We said it does. Thirdly, when is the Public Service Commission, or indeed any other service commission, entitled to depart from qualifications set by the executive? And I'll come back to that. In certain circumstances, we accept it can, but not normally, but I will expand on that. And the fourth question is the effect of Section 14 of the Civil Service Act. Just turning to the first point, the proper construction of Regulation 8, we say, if you go to Regulation 8, which is at, I think, 1192, page 1192, you say the construction is absolutely plain beyond argument. Regulation 8.1, essentially. And we say it is clear beyond argument that the decision ultimately is for the Chief Fire Officer, and it is not merely an advice as to whether there's an equivalency in qualifications. It is his decision is binding, subject no doubt to judicial review considerations, but that's it. So Regulation 8, on satisfying the requirements, a candidate for appointment to the office of Fire Station Officer shall be a person holding the office of Fire Station Sub-Officer, and we say, well, that's obviously mandatory, and who has passed a job-related written exam, or is the holder of the graduate diploma of the Institution of Fire Engineers or equivalent related qualification as determined by the Chief Fire Officer after consultation with the Permanent Secretary and the Chief Personnel Officer. And then there are further provisions in subsections 2 and 3. But we say it is plain from this that the person who has to determine equivalency is the Chief Fire Officer. It is his decision. It is not the decision of the Chief Personnel Officer. It's not the decision of the Permanent Secretary, and it's not the decision of the Service Commission. So that is, we say, the starting point. And I don't think, my Lords, there was any dispute that that is the natural meaning of this regulation, even in the Court of Appeal. And just as far as the power under which this was passed, this is at 1156, and these regulations, it's important to note, were passed under the Fire Service Act. They weren't passed under the Constitution, but in practice that doesn't make any difference. And you can find at 1156, the Fire Service Act, Regulation 34.1, the President may make regulations for carrying out or giving effect to this Act, and in particular for the following matters. A, for prescribing the terms and conditions of employment in the fire service. A, for prescribing qualifications for appointment to an office in the fire service. So we say Regulation 8 plainly comes within subsection A. So there's nothing wrong. It's perfectly clear what it means, and further, there's nothing ultra vires in what it means on a natural construction. Just a couple of points, just to pick up things said in the Court of Appeal. We accept that the Chief Fire Officer cannot surrender his discretion to the Chief Personnel Officer, as said by the Court of Appeal. You see that at page 148, paragraphs 11 and 13. That's obviously right. Whether or not he did that in this case, well, that's a matter for argument between the appellants and the respondent. We accept that also, in principle, the qualification which is accepted as giving rise to an exemption under Regulation 8.3 could, in principle, depending on what it is, also amount to an equivalent qualification for the purpose of Section 8, Regulation 8.1b. In principle, it could happen, but it might be a very unusual case. But there could be, if one goes, if I may, just go back to Regulation 8, 1192, (8.1b) is the holder of the graduate diploma of the Institution of Fire Engineers or equivalent related qualification as determined by the Chief Fire Officer. So he's got to do that in any event. We accept that. But what, in theory, he could do, I think this is what the Court of Appeal held, is, for instance, if you look at, go over the page to 1193, where a candidate for appointment to the office has served at least 5 years in the office of Fire Station Officer, he shall be required to pass examinations conducted by the Examinations Board. And my Lord, I think we would accept that if there has been, if there's been, it seems that there appears to be a power to exempt from that, then, well, if he has that, I should have said this, if he has that qualification, in other words, if he has passed examinations and management studies conducted by the Examinations Board, And if, for whatever reason, but we say it's pretty unlikely, the Chief Fire Officer says, well, that's good enough for me, that's equivalent as far as I'm concerned, then, my Lord, we wouldn't necessarily dispute that that can be done. It might be a very unusual case. That's a different point.
That's good enough to qualify 8.1b.
8.1b.
Yes.
You might have a situation where someone had done a university degree which contained numerous subjects,
exactly,
some of which were directed to fire safety, some of which were directed to management, so the same qualification might.
It might. So he might say, well, I see you've passed that examination and that's good enough for me as far as 8.1b is concerned. But this is theoretical. It doesn't arise on the facts of this case.
What about 8.3? Because I think that is where he got an exemption.
Well, I'm not sure about an exemption. I mean, what's not entirely clear, I have to admit, is why there was any exemption given at all. And one might ask reasonably, what is the power to exempt? Because our position is this: these regulations are passed, obviously after advice, and they're mandatory. And it's not open to the PSC to say, well, never mind about that, because otherwise you have chaos. No one knows where they stand.
But we needn't go into that because it's not a point that's taken.
Yeah, it's not an issue in this case. And, my lords, the other point which is made by the Court of Appeal in paragraph 10 of that judgment at page 148 is they say that the power to decide equivalence would ordinarily be reserved for the service commissions. But we say, as we set out later in the case, that's simply wrong. The power to decide the qualifications is plainly something which repeatedly occurs in either regulations or in the statutes, and that power, the power to determine qualifications, is plainly vested, has always been taken to be vested, in the executive or the relevant minister.
That's Endell Thomas.
As Endell Thompson, and also that's specifically, just going back to a point I think was raised with Mr. Datz, that issue was specifically decided by the Court of Appeal in the Ramsahai case, which was about teaching service commissions. That, I think it's fair to say, is the only case which is what you might call attacked head-on, the same point that the Court of Appeal attacked.
And that case?
Ramsahai. Ramsahai. And that was decided in the Court of Appeal, where they essentially said, well, it might all be jolly unfair what the regulation says, but you didn't qualify for 5 years at the relevant, by the time of submitting your application. Therefore, it's irrelevant that you had 5 years qualification by the time you were interviewed.
And the reference to that?
I think it's actually in a supplemental bundle. We've got the wrong one in the main bundle. It came in this morning, and that's the Court of Appeal's decision. I will come to that later.
Thank you.
And it's in the supplemental bundle, I think came in on its own. That was upheld by the Privy Council, but the point wasn't then attacked head-on in the Privy Council. It was taken as read. And one other point I want to make about Regulation 18, which is fundamental, because it's the problem which the word eligibility gives rise to. There's an ambiguity in it. Now, the Court of Appeal, if you go to page 156, paragraphs 47 to 60, they suggest that eligibility in Regulation 18, that isn't directly an issue in this case, but it touches on it, of the Public Service Commissions, refers to minimum requirements. So if I can take you first of all to the Court of Appeal's decision, I think it's at page 156.
Sorry, there was a minute.
It's in the key documents bundle too, but it's at 156.
First sentence.
First sentence, yes.
Are you saying that's wrong?
I am.
Right.
Completely wrong in the context of Regulation 18. It's flatly inconsistent with the decision of the Privy Council, which I'll show you in a moment. And it is important, because this word eligibility is used in different ways in different sections. And so one of the problems of the Court of Appeal's judgment is that it makes this assumption about eligibility. And so it starts from the point that eligibility in Regulation 18, which is, so to speak, the governing provision generally for promotions and so forth, they start from this as their starting point, and it's from this they gradually move on to their conclusion. And we say that is simply wrong. They then go on to refer to Regulation 18 of the regulations. Under that regulation, determination of eligibility is the sole province of the PSC. This is consistent with its constitutional remit and purpose. The PSC controls the gateway for those who are to be considered for employment promotion. It must therefore set the criteria and, by implication, minimum requirements. One exception is where they are set by primary legislation, which involves legislative as opposed to executive intervention. Among the factors determining eligibility are seniority, experience, educational qualifications, merit and ability. Regulation 18 is contained in Chapter 3. Now, one of the problems with this case is that it appears that the Court of Appeal really made all these findings and went into these of law without any warning. The parties weren't arguing this. And there's a Privy Council decision which is flatly contradicts it. And if I may, it's the case of Sankar, which one finds at page 2193. Begins at 2193. And this was a case in which the Public Service Commission introduced a new method of interviewing people called ACE, which had been imported from Canada. And the people who lost, naturally enough, said, well, that didn't comply with Regulation 18, who, as it were, applied this fancy new Canadian way of interviewing people, and you had no power to do so. And one of the questions that arose was, what is the proper construction of Regulation 18? Now, Regulation 18 is cited at 2201. And this is what the Court of Appeal is talking about. In considering the eligibility of officers for promotion, the Commission shall take into account seniority, experience, educational qualifications, and so forth. And then you can see various other things that the Commission has to do. It begins at Regulation 18, but the word, and the important word for present purposes, is eligibility of officers. And the board recites.
Which paragraph are you reading from?
I'm terribly sorry. It's 2201, page 2201, and it is paragraph, that is to say, regulation. Well, it's paragraph 16 of the board's decision, but paragraph regulation 18, right at the foot of 2201. Forgive me. So that's where this word comes in, and it's been there, as it were, since the beginning of time, in considering the eligibility of officers for promotion. And that's in Regulation 18.1. You take into account seniority and all the other things there. And then sub-regulation 2, the Commission, in considering the eligibility of officers under sub-regulation 1, shall take into account, and so on and so forth, seniority, merit and ability, in the performance of its functions, and then you take into account various other things. Now, the important point about the decision of the Privy Council, you can pick it up at paragraph 17 on page 2203. In the courts below, the Commission made submissions to the effect that Regulation 14, which I haven't taken you to, operated independently of 18, and that the ACE procedure could be justified simply on the basis that it was a form of competition. Before the board, Mr. Knox made the more limited submission that both regulations are relevant to the present case, but that Regulation 18 only applies to the initial decision to accept a candidate for consideration and promotion, not to the ultimate decision whether or not actually to promote him or her. He based his submission on the presence in Regulation 18 of the word eligibility. So, my lords, that was my submission was basically the Court of Appeal's view. However, the Privy Council then go on to say in paragraph 18, that's just not right. It's true that this word can have the threshold meaning assigned to it by that submission, as the word eligible in 13 appears to. But in the context of Regulation 18, the board has no doubt that the word eligibility is the equivalent of suitability and relates to the final decision whether or not to promote. Otherwise, the regulation will contain no criteria regarding the basis for final decisions on whether to promote. The board therefore agrees with the Court of Appeal that you must read the two regulations together, Where a promotion is to be made from within the public service, it should be made by competition. But the decision of which of the competitive approach should be made taking into account the criteria set out in Regulation 18. So that, my lords, we say, is what Regulation 18 is meant to mean. It doesn't mean, it means suitability, not threshold, that you meet threshold requirements. And again, paragraph 28 on page 2209.
Sorry, eligibility means suitability, not threshold.
Suitability, yeah.
So that it has a different meaning,
exactly.
The word eligible, in the fire service regulations.
Precisely. And this is one, and the problem with the Court of Appeal's judgment. It takes that word in the PSC regulation and sort of moves on from there, but it just misinterprets it. And then you go to paragraph 28. There's another discussion about what Regulation 18.4 means in the context of eligibility. Second and crucial question, this is paragraph 28, is whether it was legitimate to use the ACE as a shortlisting procedure, bearing in mind it could cover only...
I'm sorry, you'll have to bear with me. Paragraph 28.
28 on 2209.
Perhaps before you go there, I should ask you to comment on paragraph 49 of the Court of Appeal's judgment.
No. Well, it's all hinged on paragraph 49, but there's also paragraph 28 in the Privy Council's decision in Sankar.
Right.
Is it 2,209?
But as pointing out that in paragraph 49,
yes,
the Court of Appeal says that Regulation 18 no longer applied to the fire service.
Exactly. It does, but it uses, I'll come to the Court of Appeal's judgment in more detail later, but it uses, so to speak, this as an introduction to the point that it's always been for the Public Service Commission to decide threshold eligibility. And that's why you should not, that's why Regulation 8 is inconsistent with Regulation 18. My point is it's not at all inconsistent. But my lord, you're right. Regulation 18 strictly doesn't apply to fire service officers. But 2209, paragraph 28, crucial question is whether it was legitimate to use ACE as a shortlisting procedure. The Court of Appeal thought it was on the basis that passing the ACE could be regarded as a further specification required for appointment to the particular office within Regulation 18.4. Now that is, in other words, by the Public Service Commission. The Court of Appeal raised this possibility and concluded that a specification within Regulation 18.4 need not be required by the employer, the minister or ministry, but could be required by the Commission itself. The Board doubts whether this analysis is sustainable. Regulation 18.4 directs the Commission to consider any specification that may be required from time to time for appointment. It does not authorise the Commission itself to introduce specifications. I draw attention to that because it anticipates a point that I'll be making later. The minimum requirement specifications, if I call them that, are purely for the executive, and you see support for that, albeit obiter, in this here. But this case, I submit, is very important because it, A, alerts one to the dangers of looking too closely at the word eligible without reference to a definition, and secondly, it proceeds on the premise it's for the executive, the relevant executive, to set specifications in the sense of minimum criteria. Now, my lord, that's what I say about Regulation 8. I'd now like to move to my second point, which is the constitutionality of Regulation 8. I see what the time is. I'm quite happy to break now or carry on for a moment or two. Quite happy, my lord.
Whichever you would prefer.
Well, perhaps I shall just start off and just get them. Now, I make the simple point that on the natural construction of both Regulation 8 of the regulations and Section 31, 1AA, both of them are consistent with the Constitution. I submit that is clear from A, the wording of the Constitution itself, and B, the authorities. And the two most important authorities are Endell Thomas, where it's said in passing, it is fair to say, but nonetheless authoritatively, that it is for essentially the executive to set specifications, the minimum specifications. And that is also, as I said a moment ago, what is said by the Court of Appeal in Trinidad and Tobago in the Ramsay case. And I say that there is no discretion to depart from the minimum criteria where they are laid down in a regulation. Now, if I can just go, first of all, to the Court of Appeal's decision quite quickly, because there are numerous places where it just goes wrong. And the trouble is, if you don't pick it up right at the beginning, one gets the impression that it all makes sense. The difficulty is the starting point is completely wrong. And now it begins, or the relevant passages begin at 155.
Is that a paragraph or page?
Page number 155, paragraph 46.
Thank you.
This is where they turn to the Public Service Commission regulations, and this is the first section, if I can put it this way, of their judgment on this issue. And then on 156, you get to explanation of terms and statutory framework, and then you have eligible, the paragraph I took to a moment ago. It then goes on to discuss Regulation 158H. Now, if I can just say something about Regulation 158H of the PSC regulations, because that has a different definition of eligible. And that's important in the context of this case. That, my lords, is at 1021. You start at 1021 and 1025. Now, this is the Fire Service Commission this is the Public Service Commission regulations passed by the President under the Constitution, not passed by the President under the Fire Service Act.
The Public Service Regulation.
Public Service Regulation, yes. And you'll see the definition. Here you have the Fire Service, and these were essentially a new raft of provisions introduced in 2011, I think. But you'll see the definition of eligible officer. Eligible officer means a fire officer who satisfies the qualifications of an office. Well, we say yes. Now that's much more like what we say, one might think normally means. But anyway, that's what it means here. Different, in other words, from what you find in Regulation 18. And then you go to 158. This is what you might call the notionally equivalent provision to Regulation 18.
Sorry,
158.
Electronic page, or Regulation 158.
Regulation 158, sorry, my lord, page 1025. And here, you've got a sort of quasi-mirror provision to Regulation 18, but it's not. But it says, in considering eligible fire officers for promotion, the Commission shall take into account, and so forth. So what happens when you're applying to be for promotion, let's say as a fire officer, is you do have to, it is built into Regulation 158 that you have to be, quote, eligible, and therefore have to have met the qualifications. So there is that distinction, and we say a rather important distinction when you're construing the regulations and looking at the constitutionality of them, in looking at different definitions of eligible, the two different parts of the regulations. Oh, forgive me, I said the PSC regulations made by the President. Mr. Strang correctly reminds me they are made by the PSC, I think, on the advice or with the concurrence of the Prime Minister. Yeah. My Lord, that may be a convenient point if it is for you. I'm quite happy to carry on.
Well, we're on the dot of 3 o'clock. So we'll rise now for 20 minutes and we'll sit again. And I think this is, yes, at 3:20. You'll have another half an hour then. I don't think that clock's working.
Is it not?
I can't see it. I can't see it because of the reflection,
a little
reflection
fast,
of the light.
I think.
But
I see.
it's now 2 minutes past 3, and we'll sit again at 20 past, and you'll have another 30 minutes then. Thank you, Mr. Lord.